Welcome to another episode of The Law Mogul. I'm your host, Attorney Sean Mogul. Today we're talking about Form I-1290B, Notice of Immigration Appeal or Motion to Reopen/Reconsider. This form is filed with U.S. Citizenship and Immigration Services in certain circumstances, and it is used for two purposes: either to file an appeal in certain circumstances or to file a motion to reopen or reconsider in a particular case. When should you use Form I-1290B, motion to reopen, or when you're using it as an appeal? It is used to file an appeal with the Administrative Appeals Office, or you can also use that form to file a motion to reopen or reconsider with the Administrative Appeals Office, or with a service center or a local field office's decision. For example, petitions for alien relative I-130 petitions. You cannot use Form I-1290B to file an appeal on a decision on an I-130 case. You would need to use Form EOIR-29. But you can file a motion to reopen or reconsider a decision from a Form I-130's decision. If it's denied, then you can use Form I-1290B to file a motion to reopen/reconsider. Basically, the same form is used for many different type of appeals or motions to reopen or reconsider, and it gives a avenue in a case where a decision was made incorrectly and you would like an immigration officer to reconsider that decision with new evidence or better explaining the evidence that you had submitted. The type of information that you're going to need to file a Form I-1290B is going to be basic information: your name, your phone number, your address, but also the case number for the underlying case in which you are filing either an appeal or a motion to reopen or reconsider, along with years of information such as 5 years of history, information that was provided on the underlying form, and things like that. The information that you're going to be providing for the basis for either your appeal or motion to reopen or reconsider will depend on the type of case that you are filing either an appeal for or a motion to reopen or reconsider. For example, if you're filing an appeal, you would select under Section 3 of Form I-1290B that you're filing an appeal right now, but you'll be submitting additional documents and a brief in 30 days. Or that you're filing an appeal right now and you're submitting everything, all the evidence in support of that. Or that you are filing a motion to reopen or reconsider. In that situation, you'd be selecting a different box. For example, if you're filing a motion to reopen, then you would select filing a motion to reopen along with attaching additional evidence. Or if you're filing a motion to reconsider, you would file a motion to reconsider with a brief and additional evidence attached. In addition to the documents, additional evidence, and brief that you may be submitting with your Form I-1290B motion to reopen or your appeal, you're going to need to file a filing fee. The current filing fee for Form I-1290B is $675. That fee can be waived if you can demonstrate that you are either experiencing financial hardship or that your household income is below the poverty guidelines. Is there a time limit to file your Form I-1290B appeal or motion to reopen or reconsider? Generally, you have 30 days from the decision, from the date an immigration officer made a decision, to file an appeal. And if that decision was mailed to you, then you generally have 33 days. But a motion to reopen or reconsider could be filed at a later time if circumstances were such that you were not notified of the decision. But generally you want to file your motion to reopen or reconsider, or if you're filing an appeal, immediately, as soon as possible, as soon as you've gathered your evidence. I hope this information was helpful. Thank you for joining me, I'm your host, Attorney Sean Mo.